Thank you very much, Jocelyn. It's always a pleasure to join LAAC for these webinars. My name is Eric Sapp. I'm a staff attorney at Legal Services for Prisoners with Children. Legal Services for Prisoners with Children is a support center. We do legal support in the form of trainings such as this. We do technical assistance, which means that qualified legal services providers can come to us with legal questions about cases they work on or issues that they come up a lot, and we can provide research and counsel to assist them. And we do advocacy support, both in the form of legislative reform and impact litigation. It's, I suppose, fitting that the weather here in the Bay Area, where I'm speaking from, is there's a lot of wind and rain, which automatically and physically thematizes the issue of shelter, which we're going to be talking about. And it's also a great honor and privilege to welcome Andrew Ntim as my co-speaker tonight. I had the privilege of literally observing him become a lawyer, in the sense that when he passed the bar, he was a fellow here at LSPC, but now he works at the Lawyers Committee for Civil Rights of the SF Bay Area. Andrew is a permanent staff attorney and a 2024 to 2025 Change Lawyers Fellow at Lawyers Committee for Civil Rights. As a staff attorney, he works on the racial justice team to advocate on behalf of people experiencing homelessness and living in poverty in California. He also fights for those advocating for social change who have faced violence and retaliation by police. He supports litigation seeking to transform Sacramento's police responses to protest, disrupt the sweeping property destruction of the possessions of unhoused persons, and to end San Francisco's practice of summarily towing legally parked vehicles and imposing burdensome fees due to parking tickets without assessing ability to pay. Additionally, Andrew works in a coalition with homeless advocacy and anti-police terror groups to push legislation addressing those practices. I'm going to speak first, then I'll hand the mic over to Andrew. Then we'll have a Q&A session where anyone who wants to can signal with the virtual hand, and you'll be able to take the mic. You can also write your questions either in the Q&A function or the chat, and my colleague Mitra will be monitoring the chat and is willing to read out those questions if someone doesn't want to read them aloud. If anyone needs copies of materials and slides, feel free to email us after the event, and we'll help get that to you. So I'm going to share my screen and get started. Let's see. All right. On the screen is a painting by Picasso, La Miséreuse Accroupie, impoverished woman crouching from 1902 in the so-called blue period. We're going to talk about three cases today. One is, at least at the appellate level, over. That is the Grants Pass versus Johnson case. I'm going to say a little bit about that, that the Supreme Court decided last summer. And then I'm going to talk about a case that is not, has barely just begun, which is the ordinance in Fremont, which has been just recently introduced in the wake of Grants Pass, and sort of extending it here in the Bay Area in a municipal ordinance that the city of Fremont has adopted. That has not yet given rise to litigation that I'm aware of, but already a coalition, including I think both of our organizations, although I wasn't involved in it, and led by the ACLU, had submitted a letter of opposition earlier this month to that municipal ordinance. Then I'm going to hand the mic over to Andrew to talk about the litigation that he's involved with in San Francisco regarding its response to the housing crisis in San Francisco. And that's a ongoing litigation and very interesting. Now, my training is in the humanities, so I'm going to first take a step back and talk a little bit about philosophy and literature. Gorsuch's opinion tries to take the question of equality out of the calculus of cruelty, which was the focus in Grants Pass under the Eighth Amendment. But I think it's important to understand the backdrop of inequality that shapes the issue of housing and the status of being unhoused or unsheltered. And also to reflect to what extent it is the case that a regime of merely formal equality is itself a regime of cruelty. The concept of isonomia is an ancient Greek term, probably at least first surviving recording of it is in a poem, author unknown, but believed to be a poet by the name of Callistratus, who wrote a hymn to Harmodius and Aristogeiton, who were two would-be revolutionaries who tried to overthrow a tyrannical regime in Athens. One died in the attempt, and the other was later caught and put to death. They didn't directly overthrow the tyrant's regime, although they're credited with later reforms that brought about a system, flawed as it was, that was among the paradigms of democracy in the West. This term isonomia occurs in that hymn. It's translated variously as equal laws, equal rights. You could translate it as equality before the law or equality under the law. And the prefix iso is familiar from the geometry of triangles, like an isosceles triangle has two equal sides. The nomia part is that of nomos, which is often translated as law. Some of the semantic field of nomos is covered by the semantic field of English term law, but it could also be understood in terms of equal rights here. I mentioned this concept as one that's present in the history of Western law and politics, but not necessarily as a dominant feature of that the same. I would say that rather, for the bulk of 2.5 millennia from the time of that event solemnized in a hymn to the Enlightenment, that a principle of inequality sort of reigned in Western law, and that is the superficially similar idea of treat like cases alike and different cases differently, but the differently side of that and the conception of what is a like case, both in the civil law system and in the common law system, was for the bulk of Western history the basis for justifying a lot of, or at least the juridical excuse for a lot of inequality. That changed on a formal level in the Enlightenment, where the notion of equality came to the fore, especially in a legal and political and civil context. Although, as everyone is aware, formal equality does not equal material equality. One of the thinkers from that era, in the mid-18th century, Rousseau, after in the body of the text of Book 1 of the Social Contract, where he had been describing the way that a civil state through law creates a moral and legitimate equality amongst persons who are without it unequal. Now he uses the word natural to describe that inequality, but we could also think of it as social. And so in the body of the text, there is a kind of idealistic statement, but there appears a footnote which presents a realistic critique of that idealistic statement of equality. And that footnote is here on the screen in Cole's translation. Under bad governments, this equality is only apparent and illusory. It serves only to keep the pauper in his poverty and the rich man in the position he has usurped. In fact, laws are always of use to those who possess and harmful to those who have nothing, from which it follows that the social state is advantageous to men only when all have something and none too much. Now, the word translated by Cole as harmful is nuisible. I'll come back to that later when we talk about nuisance in the context of Fremont. I just want to flag it right here. Now, about a little under a century and a half later, the novelist Anatole France wrote a very famous line, which is actually from a novel, a historical novel called The Red Lily. And that sort of fragment of a longer speech says the magisterial equality of the laws which prohibit the rich as well as the poor from sleeping beneath bridges, from begging in the streets, and from stealing bread. Later in the same speech, the same fictional character says of the dominant order resulting from the French Revolution, we have made laws against indignation and pity. And there the pity referred to is a feeling of solidarity with the poor. I mentioned those as a long preface to the case Grants Pass versus Johnson, which will echo the first quote from France, and then the Fremont ordinance will echo the second one, as we'll see. So Grants Pass versus Johnson case arose from a municipality in Southern Oregon, which passed an anti-camping ordinance, and it was enjoined by lower courts applying Ninth Circuit precedent Martin versus Boise, came up to the Supreme Court, was decided in summer of 2024. And the Supreme Court, Gorsuch was writing for the majority, held that the federal Constitution's Eighth Amendment ban on cruel and unusual punishment did not prevent the municipality from prohibiting camping in public places. And it was a fairly broad definition of what a campsite is, which included a parked vehicle. As Sotomayor pointed out in the dissent, these details didn't even make it into the majority's opinion. The ordinance prohibited camping on any sidewalk, street, alley, park, bench, or other publicly owned property, or under any bridge or viaduct. Now, I added emphasis to this phrase, under any bridge, because it is the direct echo of the position that Anatole France had articulated over a century ago as a satirical ridicule of an oppressive social order. But now, in our time, satire is dead, and the ridiculous is the real. Gorsuch responds to the dissent with the following remark, which I'll quote. At times, the dissent seems to suggest mistakenly that laws like grants passes apply only to the homeless. That view finds no support in the laws before us. The court distinguished its own prior decision in Robinson versus California from 1962. Robinson had found that an Eighth Amendment violation, cruel and unusual punishment, was found where the status of a narcotics addiction was criminalized. Instead, the court in Grants Pass finds that the municipality is not criminalizing the status of being unhoused, but rather criminalizing the act of camping. Now, this is a rather nice semantic distinction, but the court doesn't explain in any way how something like falling asleep, which is a paradigmatically involuntary behavior, constitutes an act at all, let alone one that would have adequate mens rea for a criminalization. But the court doesn't really explain why this is an act rather than a status that's being criminalized. Because if it was a status, it would be a violation of Eighth Amendment under the Robinson line of cases, which the court did not overturn, but simply distinguished or limited. Now I'll turn to the second example. Again, reminding us of the quote from that novel, we have made laws against indignation of pity. And I'll talk about the Fremont ordinance, which I believe just passed a few days ago. And I believe it passed in the form that was originally announced. If I'm wrong about that, you can treat what follows as a very concrete hypothetical, but I'm pretty sure this is what actually passed. So Fremont's ordinance begins with a long preamble with about 10 different whereases explaining all the noble efforts that the city did to address the housing problem. I just focus on a few passages from that and call attention to some of the subtleties of the language they use. Whereas the city engages in outreach work to build relationships with people experiencing homelessness, using a person-centered, compassionate approach to provide services tailored to each person's specific needs. And whereas the city provides housing stability support, eviction protection, transitional housing, and supportive and permanent housing solutions to people to assist people with ending their homelessness, etc. Now, I want to call attention to this phrase, their homelessness. It is not our homelessness problem, our being a city, a state, the United States, the global capitalist order, or even humanity's homelessness problem. There is a famous line from the philosopher Heidegger, which asks, what if man's homelessness consists in this, that man does not even think of the real plight of dwelling as the plight? Returning to Fremont, their homelessness does, however, recognize the right of unhoused people to have possessions. They can possess their homelessness through the possessive pronoun there. And they can also possess personal property, which much of the ordinance takes pains to describe what happens when someone stores personal property, be it attended or unattended, on public property or private property without authorization from the owner, or without the limitations on the ability of private property owners to allow people to put personal belongings on their property. But at the end of the day, what the ordinance does is authorize the seizure of personal property of unhoused persons, and also criminalizes camping. The on the screen is a section from the municipal code describing what the definition of camp means, or camp facilities, camp paraphernalia. Interestingly, camp facilities is not limited to what's listed, so it's an open-ended thing. Camp facilities include, but are not limited to, tents, huts, vehicles, vehicle camping outfits, or temporary shelter. Camp paraphernalia includes, but is not limited to, things like sleeping bags. The Fremont ordinance does effectively two important things. First, it establishes a criminal offense, a misdemeanor, punishable by up to $1,000 fine, 6 months in jail, or both, for, quote, any person causing, permitting, aiding, abetting, or concealing a violation of this chapter, which includes the both the camping or the storing of property in an unauthorized manner, shall be guilty of a misdemeanor. And secondly, it declares violations to be public nuisances subject to abatement. Now, it's important to recognize that not only does, as this internal reference shows, Fremont already has a nuisance law in its procedures outlined in its code, and the state of California has public nuisance law applicable statewide. So to abate an actual public nuisance, that is one that fits a traditional conception of public nuisance, this ordinance is not needed. They could have abated public nuisances that are actually public nuisances through existing law. What this law does is expand the conception of a public nuisance in the city of Fremont by declaring all the violations of the ordinance to be public nuisances. Now, as I hinted at or stated earlier, this notion of nuisance is the same, etymological root as the term used by Rousseau in describing the law as harmful to the poor. That is, the law itself is a nuisance if you have impoverished, if you're impoverished. Last, I just want to note, maybe on a less depressing note, but no less attentive to the absurdities of laws of this nature. The severability section in Fremont's ordinance is a very broad one. Severability clauses are quite common to preserve the validity of portions of a law that survive a challenge which finds other portions of the law invalid. Fremont's ordinance drafters chose to articulate a very broad and extreme severability clause, which I will read here and suggest a application of it, partly in jest, but as a moral lesson, so to speak. City of Fremont hereby declares that it would have passed this ordinance and each section or subsection, sentence, clause, and phrase thereof, irrespective of the fact that any one or more section, subsection, sentences, clauses, or phrases be declared invalid. Now, one of the sections of the ordinance, 8.90.60, enforcement, in paragraph 2 of subdivision A, says, as highlighted on the screen, nothing in this section or this chapter shall require the city to provide housing to such violator. So I would suggest the severability clause taken literally means that you can delete any phrase from that and it still reflects the intent of Fremont, which in this case is buried under Freudian verneinung. So I would propose, invalidating the phrase "nothing in this section" and leaving behind only what's highlighted here. This chapter shall require the city to provide housing. And put my email for contact later, and I will pass the mic to my colleague, Andrew.
Thanks so much, Eric. I really appreciate it. And let's see, can folks see my screen, hear me okay? Awesome. Okay. Um, well, and thank you for the amazing introduction earlier on. I really appreciate it. Here, this is me, staff attorney at Lawyers Committee for Civil Rights, of the SF Bay Area. That's also me, wearing the same shirt, in fact, longer hair though, 2 weeks back, 2 years back. That was when I was at LSPC and definitely miss it quite a bit. So I do not have the experience or history of either close reading of Grants Pass or humanities and philosophy. So this may be a bit of a different presentation, but I hope it will be useful nonetheless. Let's see. In my I don't know if it's overachieving or underachieving, have too many slides and not enough time. So I want to focus in on the things that folks here are most interested in and have perhaps the least background in. So generally the things I have slides on here are background on homelessness policy in San Francisco, background on our lawsuit, the Coalition on Homelessness against the City of San Francisco. And then some things that I've added in are changes in law and policy over the past several months in SF and beyond, as well as some legal strategies to consider. And I really want to focus in on some of those legal strategies because I know we're in a moment where these attacks are feeling more and more urgent. And we feel like some of our legal tools have been taken away. So I want to definitely make some time for that. And then ways for folks to plug in. And I've heard from Yoseline that pretty much everyone here is from California, but there are some folks from outside of the Bay Area. So I guess I want to start by asking, and folks can, thumbs up or thumbs down, whether they have familiarity both broadly kind of with homelessness policy in the Bay Area, as well as the specific lawsuit, the Coalition on Homelessness versus San Francisco. So I think I can see like reaction. So if folks don't know, especially, then give a thumbs down so I know what to focus in on. And also just disclaimer, things are very in flux. There's a lot of uncertainty as to how grants pass and how other lawsuits may affect our ability to approach these sorts of things, including things you might not expect, such as the mifepristone case and its effect on organizational standing and how different organizations can kind of attack some of these things. So a lot is in flux, and I request that folks don't share these slides or the recording kind of outside of this group, especially around the legal strategies, because there are some ongoing conversations within coalitions that I think we want to keep private. So broadly, homelessness in San Francisco, and these slides are from a few months ago. So according to the point in time count, things have actually gotten worse since, but we have more than 4,000 people unsheltered on the street, not even with a vehicular shelter, that are trying to survive in San Francisco. There's an acute lack of shelter services and affordable housing, and there's many people that are waiting for shelter on the reopened shelter wait list, and even more that are not formally on the wait list, but have attempted to kind of get access to shelter and have been unable. And there is a very extensive regime of criminalization and property destruction in the city of San Francisco. This is something that also occurs in many cities around the country. There was a recent ProPublica report around the destruction of property and survival gear throughout the country. I think they surveyed 14 different cities, and I really recommend looking into that both as kind of a look into what's happening in San Francisco and what's happening around the country. Um, Now, these are just some of the laws. I won't go into this in depth, but that are used in this regime of criminalization. And these may be similar to ones in cities that you all live in as well. And we have, the classic 168 sit lie prohibition, the unlawful lodging 647E, 148A resisting, delaying, or obstructing a public officer, peace officer. And this is one that is often used even in cities that don't have explicit sit lie restrictions as a way of criminalizing that and forcing people to move or to give up their possessions. We have the police code 22-24 around obstructing free passage, which is again used very selectively. Public nuisance, which Eric talked about briefly, and 647C around obstructing free movement in public place. And all of these, are a part of a larger regime of intimidation and oppression that forces people to move and forces them to give up their belongings. And even if, folks are not frequently, arrested and put in jail on some of these, it is the mere threat of being able to run these or run folks for other warrants they might have becomes an extremely oppressive and coercive way of forcing people to move. And some of these and more are in a police bulletin that I can share after the presentation. Now, next, I want to talk about San Francisco's bag and tag policy, which is relatively unique and relatively strong. And it basically says that all items picked up by our Department of Public Works must be bagged and tagged, including bulky items like mattresses, except for abandoned property, trash, perishables, and items causing a safety risk. That folks must provide a reasonable time to move their belongings. Generally, that there is notice of scheduled encampment sweeps, though that has changed under new policies for quote unquote re-encampment, and that folks are able to get these bag and tag forms. But both before our lawsuit and after, we have many, many examples of San Francisco not following its own policies, of DPW destroying properties that are clearly not abandoned or trash, of them considering things that are not soiled to be trash, or, destroying them and then considering them to be trash. And thinking of certain things that are temporarily unattended as abandoned, even if someone might be away for just 5 minutes, and of folks not getting enough time to move their belongings, especially folks with disabilities. So, in consideration, both of this long list of criminal and civil laws, as well as the bag and tag policy not being followed, we, in a collaboration with the ACLU and the Coalition on Homelessness, filed this lawsuit against the city of San Francisco. We also had 6 individual plaintiffs initially. In September 2022, stating that the city was violating its own policies when it came to bagging and tagging and destruction of property, as well as initially under the pre-Grants Pass Boise case, Martin v. Boise, that the criminal enforcement of sweeps was violating the Eighth Amendment. And we had an injunction that was granted in December 2022 and upheld by the Ninth Circuit, basically stating that and I can go into that, that there were restrictions on the way they could criminally enforce some of these laws. So basically, all of the laws that you saw a few slides ago, those were seen as those were enjoined basically from December 2022 until 2024 after the Grants Pass decision. And they also required compliance with bag and tag, which is ongoing. That part of the injunction still stands. And importantly, I think there was a lot of misplaced rhetoric around this injunction, stating that it wasn't allowing them to do cleanings, not allowing them to move anyone, not allowing them to deal with genuine criminal activity. And this was not the case. It didn't prohibit SF from addressing encampments or enforcing most laws. including the clearing of sidewalks. It was just around following its own written bag and tag policies, and not using these these criminal uh, these criminal tools, except for 148A, which was the obstruction of a lawful purpose one, which, as we'll see, it continues to move forward. And going back just once, there were some other claims besides those. There were disability claims, state-created danger claims, which related to the destruction of survival items, as well as sweeps during inclement weather, and 14th Amendment procedural due process claims, around both the destruction of property um, and the seizing of folks. Um, so Grants Pass, I think that Eric did a really excellent job, kind of discussing what the main changes were coming from that. And basically, as it pertains to our case, it stated that states and localities may impose criminal penalties for acts like public camping without violating the Eighth Amendment, even if they lack sufficient available shelter. But it did not affect rights related to property destruction, ADA, or other legal protections for unhoused persons. It also didn't affect if there are stronger state constitutional claims or state constitutional protections for cruel and unusual punishment. It did not affect those as well. So, how did this affect our lawsuit? And as I just mentioned, the Ninth Circuit modified our injunction, vacating the portion of it related to enforcement of anti-homeless laws, but continued the requirement that SF follow its bag and tag policies. And there have been, continued motions to enforce and continued monitoring of the bag and tag violations that are occurring in San Francisco, especially that are occurring during large, targeted kind of across the city sweeps, especially during APEC and other, major events that are coming to the city. They've required new trainings on bag and tag, which are ongoing, the negotiation around what those will be. And then following later on, unfortunately, there was a dismissal of our ADA and state-created danger claims related to the standing of some of our individual plaintiffs. And I'll go into that briefly later, but basically their argument was that because some of our plaintiffs had become housed or had filed administrative claims against the city, that they were not properly, part of the lawsuit. And we argued that there is a large likelihood of recurrence of homelessness for these individuals who had become housed, and that as a result, their claims shouldn't be mooted out. But unfortunately did not prevail on those arguments. And they also, these are things that certainly still can be fought on. But I think it might be fair to say that we did not have the absolute best facts when it came to some of these things. State-created danger, for example, there are examples when it comes to inclement weather of, I think in parts of Arizona when the, weather is above 110 degrees, or, in certain parts of, I think, New York and others where folks have challenged sweeps in, below freezing weather or during hurricane level events. And frankly, San Francisco, though, today shows that, it does have severe weather events, did not have facts that kind of align with some of the previous state-created danger claims. So those are fights that I think we'll live to see another day, both in the Bay Area and around the country, but is not ongoing in our case specifically. But the case is ongoing as it pertains to property destruction and bag and tag, both for the coalition and for some of our individual plaintiffs. And we will be going to trial on that in late July, or that's when the trial is scheduled. So definitely a lot of ongoing things happening there. I'm just going to skim over a few of these different things, but basically what we saw immediately after Grants Pass was a huge uptick, both in policy and rhetoric that was criminalizing and just creating much more punitive conditions for unhoused people in San Francisco. And obviously this has happened in many other places in Fremont as well, and I'll mention some of those in a second. So there was quote unquote update from Mayor Breed on San Francisco's street response that focused really on re-encampment and stated that they would, in the situations where there's this re-encampment, where they're clear an encampment and people come back, that they won't need to reoffer shelter, they won't need to provide notice, and that they are more likely uh, to issue citations in those situations. And we have seen a rise of those citations, but it's still very vague what re-encampment actually means. Is it someone coming back after 1 day, after 3 months? If it's a different group of people that are coming to that same place, is it re-encampment? And this isn't something that I've seen, explicitly challenged in San Francisco or in other jurisdictions yet, but I think is something that's ripe for challenge. Um, and so again, this is slides that I made a few months ago, but some other policy changes are that we've seen, again, these more aggressive encampment sweeps starting, even less time for folks to pack up their possessions, less offers of specific shelter, widespread property destruction. There was a very, damaging and um, just obscene executive order that was issued by Mayor Breed around requiring relocation services, which is buses, to be offered before shelter for unhoused persons. And that wasn't even necessarily to places where they had, strong family connections or had a certain place that they could go, but just anywhere that, they were previously before San Francisco. And this is very this feeds into a narrative that a lot of people are coming to San Francisco, because of weather, lax policies around homelessness, and are mostly not from here. Whereas, and I don't have the statistics immediately in front of me, but I believe it was more than 90% that are from California originally, and more than 75% that are from San Francisco or immediate, area nearby, that become unhoused. And the primary reason for people becoming unhoused is because of not being able to afford rent, and not any of these, alternative reasons. And Governor Newsom has also issued executive orders requiring state officials to dismantle homeless encampments. This is especially relevant for encampments that are on state property. And I'm already running low on time, so I'll be quick here. So further developments, there were, I believe, 14 cities that passed new anti-homelessness laws in just the month after grants pass, and dozens more that have been considered. So that was from the appeal article, and then the ProPublica article, which I mentioned previously, that spoke about how folks are, not able to get their property back after these supposed bag and tag regimes, and ongoing, criminalization that's occurring in many places. And we'll need to check in on kind of how, for the ones that have been considered, where they're going as well. Fremont, which Eric touched on very clearly, is the area that I think we were the most focused on, is the aiding or abetting of homeless camps, which is extremely vague, and could mean providing mutual aid or tents or services to individuals who are unhoused, as something that is, punishable by a fine or jail time, which we find especially punitive, and something that's also ripe for litigation on that. So that's kind of what's been going on. And now I want to take a second to focus on alternative legal strategies. And this is, I think, what I'm most interested if folks have questions on or want to know a little bit more about, and can connect with people individually on their interest around. So again, just because the cruel and unusual punishment clause, the Eighth Amendment, is no longer a feasible option for us to attack criminalization, that does not mean that there are no other ways to attack criminalization. And there are many that have been considered. There's an ongoing coalition of folks, I think, called the Housing Not Handcuffs Coalition, that is very actively, I was just on a call immediately before this, that is very actively considering other legal strategies, and they'll be convening to kind of create a toolkit and think more about what the most favorable of those legal strategies might be. And some that they've discussed are substantive due process, the right to travel specifically, which connects to banishment, the inability of folks to travel to places where they are unable to sleep, being forced to move along. There's a sort of conjoined right to travel and right to remain in some jurisdictions. And there's an ongoing case in New York that is related to that right to travel, and I also wrote a memo on that. There's state-created danger, destruction of survival belongings, and sweeps in inclement weather, which is something that has actually been reasonably successful for sweeps in inclement weather for places where there are very, very intense heat waves or very, very intense cold snaps. Right to family integrity, which has been a bit less explored and less successful, frankly, but is also a right that is within substantive due process. Disability continues to be a very strong and potentially unexplored area when it comes to preventing sweeps, preventing criminalization, all of the rest. There are accommodations during sweeps that are often not provided to disabled people, including giving folks time um, to gather their possessions and making sure that shelter is equally accessible for disabled and non-disabled people. There's a legal toolkit and an upcoming webinar that will be discussing those things as well. Um, Standing, again, I won't go into it too much, but there have been a lot of challenges to the organizational standing of both our organizational plaintiff and many organizational plaintiffs that have been bringing claims not only in the homelessness case, but lots of other cases around whether, diversion of resources and frustration of purpose is sufficient for establishing organizational standing. And so there are ongoing discussions around other ways to address standing with individual plaintiffs through taxpayer causes of action, especially for places like the Bay Area where there are, these encampment relief funds that are supposed to be used in particular ways and are often being misused. And what else do we have on here? State law, Eighth Amendment and Fourth Amendment analogs. There are some states that have much stronger Eighth Amendments that I think the big one is, what is the distinction between cruel and unusual versus cruel or unusual punishment? That's still being explored in some states. And finally, the First Amendment. So we initially had some discussions of religious discrimination within shelters that were, Christian or connected to a faith and required folks to take part in that faith in one way or another. And some folks that are also exploring the First Amendment rights of people in protest encampments, which is happening relatively frequently, or a lot more frequently now. In Berkeley, there's a group called Where Do We Go that has set up protest encampments in different parts of the Bay Area, and thinking about legal challenges to the breakup of those camps as well. Let me see if there's anything else with alternative legal strategies. Yeah, so I mean, a lot of these are being explored by other organizations, and I have some, memos and folks that I can connect with on that. There is obviously Fourth Amendment seizure when it comes to possessions. That is kind of the core of our property destruction bag and tag claim, but there's also Fourth Amendment seizure when it comes to persons and lawful seizure. You could have ordinances that are void for vagueness. And many, many other things. So that I'll stop there because there's many, many things that could fall into those alternative legal strategies. And I'll just end with ways to get involved. So as I mentioned, the Housing Not Handcuffs Coalition meets monthly. They just had their call last 1 hour ago, and they're having their big convening on March 24th. So highly recommend getting involved with them. And Will Knight is the person that kind of leads that, and he's incredible. So I definitely recommend connecting with him. Equal Rights for Every Neighbor, which is more focused a little bit on housing, but also has many pieces working on criminalization. There's the upcoming Unhoused Disability Rights webinar and Grants Pass Symposium with DREDF and Santa Clara. I, cannot overstate how important it is to get involved in kind of local community sweeps defense organizations, mutual aid collectives here in the Bay Area, organizations like our organizational plaintiff, the Coalition on Homelessness, as well as orgs like Punks with Lunch, Where Do We Go, Poor Magazine, Street Sheet have been doing the work and are just so much more knowledgeable about the things that are happening in their communities. And we found that, maintaining connections to unhoused people can be very challenging, obviously, and having those strong community connections, whether you're providing services or doing litigation or anything else, is just critical in maintaining those, and you can find many ways to get involved that you might not anticipate or even might be outside of the realm of what you think your organization can do. And finally, keep in touch, and that's my email. So feel very free to reach out. And as anticipated, I have gone over time, but welcome folks' questions about any of this, again, especially around the alternative legal strategies, and very happy to connect and provide some of these resources or answer any questions later on. And I see two questions. The first one, to what extent have you used op-eds and or local press coverage to create the kind of public moral outrage that gives elected officials enough cover to enact common sense ordinances that address homelessness without violating civil or other rights? Thank you for that question, Michelle. We, again, as with our partner, the Coalition on Homelessness, they are a very active advocacy org. I think that they've had some, op-eds and kind of traditional media coverage. They've also had many, many actions that they've supported. There was just yesterday a kind of protest action that I forget the name of, but that was pushing for the use of certain funds in more pro-housing and pro-unhoused ways. I think in the Bay and in California, there is often money in these pots that is intended to be used to support unhoused people and put them into, permanent dignified homes and shelter, but that's often just not being used very, very effectively. And I think that these public advocacy campaigns are so important to that. And yeah, I think that local press coverage and op-eds are a very effective way to address that. And it really just depends on the local political situation that you find yourself in, your community partners, the capacity of your, comms department and your organizations, if you have one, all of the rest. But it's something that we're always trying to expand on and continue forward, because these lawsuits can take a very long time and often not push for, as radical of change as we want. And so, yeah, having that public advocacy component is very important. I don't know, Eric, if you have anything to add to that.
Only thing I would add is a plug for the All of Us or None newspaper. We had a piece that I wrote on Grants Pass in the December edition of the All of Us or None newspaper. Maybe if anyone needs information about how to access that, feel free to email us. So Kelly asks, can you elaborate on how the concept of originalism influenced Grants Pass? Well, it's interesting. I'll just mention, how it plays out in the majority opinion and then in the concurrence by Thomas. So the majority opinion sort of uses an original or a take on what Gorsuch believes to be the original function of the Eighth Amendment in getting rid of extreme punishments like, quartering disembowelment and that sort of thing. So, uses it as a rhetorical device to make the use of the Eighth Amendment in this context appear somehow less important because it's not dealing with extreme forms of bodily punishment, or at least spectacular forms of punishment. And then, in Thomas's concurrence, he uses the occasion to, make a somewhat perfunctory plug for the appeal to text and original meaning in his concurrence, although it doesn't really play that much of a role in his analysis. But I think, the key thing that I would say about originalism in general is that, the idea that there is such a thing as the original meaning is an illusion, and it's really a bad faith one that shows the if someone is serious in thinking that there is such a thing as the original meaning of constitutional clauses like cruel and unusual punishment, they are either very ignorant of history, or they are trying to just put forth their take on what the original meaning is. So looking into history, I think, is always important and can be illuminating way to interpret the Constitution, but originalism as a kind of cudgel it should always be viewed with suspicion. We had a hand raised. I don't know if it's that hand is still up, but you're certainly welcome to put your hand back up. Well, while folks formulate questions, I'll ask a quick clarifying question. Andrew, was the governor's statement only pertaining to state property, or was it something broader than that, to your knowledge?
Yeah, to my knowledge, it dealt with state agencies and, property that state agencies had control over. So there are some state agencies that control or have concurrent authority with local agencies for property. I think that's especially around, there are some highways, transportation areas that have like some degree of concurrent authority. But I think there was like strong suggestions also for, local agencies to follow in line and to, engage in the same behavior. And I know that there were threats that some funding could be cut if they didn't follow what was requested, and I haven't kind of followed up on if that's happened or not. But to my knowledge, it was directly directing state agencies and areas that kind of had concurrent authority there.
And there's a question in the chat from Allison asking to speak more about standing and strategies used by government to attack standing.
Yes. Um, I was just in this meeting and I wish I could describe it slightly better. But basically, so there was a recent case around mifepristone and the FDA, and I'm gonna completely butcher this, but I think that basically there was a strong caution against using, again, frustration of purpose and diversion of resources, which are two traditional ways of approaching organizational standing, um, as means of gaining that standing. So this is less about kind of governments and more around how the courts have been taking that away. But there's been a push away from that. And there's additionally, associational standing. So the Coalition on Homelessness is also a member-based organization that has members that are unhoused that have been affected. And so that's an alternative way that folks have been approaching organizational standing. But I mean, obviously, there are ways for governments to toe the line and to as in the same way they try to moot out individuals' claims, to moot out organizations' claims. When it comes to frustration of purpose and diversion of resources. But I think it's still ongoing how exactly that's going to be felt because the mifepristone case was relatively recent. And again, I would direct you to the Housing Not Handcuffs group because it's not something that I as directly am working on. But I know there's a lot of concern that it may make it more difficult for organizations. Again, not even just in the unhoused property destruction cases, but all types of cases that involve organizational standing.
So we're out of time. I'm going to turn it over to Yoselin for an concluding message.